You have the right to be represented, at no expense to the government, by counsel of your choice authorized to practice before this court. You may be eligible for free legal services. To help you determine if you might qualify, I am hereby providing you with a list which provides contact information of the persons who might be able to assist you. During these proceedings, you will have a reasonable opportunity to examine and object to the evidence against you, to present evidence on your own behalf and to cross-examine witnesses presented by the government. At the conclusion of these proceedings, the court will decide whether or not you will be removed from the United States. Should you disagree with the court's decision, you have the right to appeal to a higher court called the Board of Immigration Appeals. To do so, you must file Form EOIR-26 within 30 calendar days after the date the court enters its decision. If the final date for filing falls on a Saturday, Sunday, or legal holiday, the time period for appeal shall be extended to the next business day. If the time period expires and no appeal has been filed, the decision of this court becomes final. I am hereby providing you with a copy of your appeal rights which you should thoroughly review. If you are ordered removed from the United States, the country to which you will be removed will be one that you choose, except as otherwise required by law. If you cannot be removed to your designated country, the court designates in the alternative the country of which you are a subject, national, or citizen, the country from which you were admitted to the U.S., the country in which is located the foreign port from which you left for the U.S. or for a foreign territory contiguous to the U.S., a country in which you resided before you entered the country from which you entered the U.S., the country in which you were born, the country that had sovereignty over your birthplace when you were born, the country in which your birthplace is located when you are ordered removed. If impracticable, unadvisable, or impossible to remove you to each country described in the previous clause of this subparagraph, you will be removed to another country whose government will accept you. Your next hearing is scheduled for September 22, 2020. If you fail to appear for this hearing and there are no exceptional circumstances beyond your control which caused your absence, a hearing may be held in your absence and an order of removal may be entered against you. Furthermore, you may become ineligible for 10 years after the date of the order of removal for voluntary departure under INA Section 240B, cancellation of removal under INA Section 240A, and for adjustment of status and change of status under INA Sections 245, 248, and 249. Exceptional circumstances which may excuse your absence are those such as if you have a serious illness, if your spouse, child, or parent has a serious illness or has died, if you, your child or parent has suffered battery or extreme cruelty, but not circumstances less compelling. You must immediately inform the court by using Form EOIR-33 whenever you change your address or telephone number. I am now providing you a copy of this form. Any change in the date of your hearing or further notices of hearings will be mailed to the last address which you provided to the court or to your counsel of record. The court will set September 22, 2020 as the deadline for receipt of your asylum application. If that application is not filed by that date, the court will deem it abandoned for lack of prosecution. Failure to timely comply with my order to provide biometrics in conformity with the applicable regulations, the instructions to the applications, the biometrics notice, and the instructions provided by the DHS constitutes an abandonment of your asylum application and will result in that application being dismissed absent good cause. Before you file an asylum application, Form I-589, the law requires that you be advised specifically about the consequences of knowingly filing a frivolous application for asylum. If you knowingly file a frivolous application for asylum, you will be barred forever from receiving any benefit under the Immigration and Nationality Act. A frivolous application for asylum is one which contains statements or responses to questions that are deliberately fabricated. Not being granted asylum does not mean that your application is frivolous. You have been granted the privilege of voluntary departure from the U.S. pursuant to INA Section 240B on, or before, September 22, 2020. If you voluntarily fail to depart the United States within this time period, you will become ineligible for 10 years from that date for certain forms of relief from removal, including voluntary departure under INA 240B, cancellation of removal under INA 240A, and for adjustment of status and change of status under INA 245, 248, and registry under INA 249. Your voluntary departure bond, if any, will also be breached. Additionally, you shall be subject to a civil penalty of $3,000. If you file a motion to reopen or reconsider during the voluntary departure period given by the judge, the grant of voluntary departure is terminated automatically and an alternate order of removal will take effect immediately. Moreover, the civil penalty and 10-year bar described in INA 240B shall not apply. You have been found eligible for relief called Deferral of Removal under the Convention Against Torture. This relief provides that your removal to your country shall be deferred because you would likely be tortured if you returned. This relief protects you only from that country and does not prevent your removal at any time to another country where you will not likely be tortured. This relief does not give you any lawful or permanent immigration status in the U.S. and will not necessarily result in your release from custody. Finally, the deferral of your removal is not necessarily permanent, it is subject to review and termination if it is determined that it is not likely that you would be tortured in that country, or if you request that the deferral of your removal be terminated. I have entered a decision finding you removable from the United States. If you disagree with my decision, you have the right to appeal to a higher court called the Board of Immigration Appeals. To perfect this appeal, you must file Form EOIR-26 with the Board of Immigration Appeals within 30 calendar days from today's date. If the final date for filing falls on a Saturday, Sunday, or legal holiday, the time period for appeal shall be extended to the next business day. If the time period expires and no appeal has been filed, the decision of this court becomes final. I am hereby providing you with a copy of your appeal rights which you should thoroughly review.